Larissa, L-A-R-I-S-A, Director Coit, and members of the board. I am the town solicitor for Indian Affairs for over a decade. Prior to that time, I represented the governor of the state of Rhode Island in connection with Indian Affairs. So what I don't know is how to sing or write poetry, but what I do know is Indian law, and in particular the jurisdictional regime governing the settlement lands. And I'm here tonight to clear up one major misperception regarding that regime. The applicant submitted a supplemental water plan, which on the first page stated that we have an agreement with the tribe concerning, quote, its sovereign lands, end quote. That's incorrect. It's incorrect not as a legal opinion, but as I'm about to show you, as a legal fact. The settlement lands are not sovereign lands. The Narragansett Indian Tribe is a sovereign people, which means their membership, their elections, how they internally deal in tribal government is none of the town's business and none of the state's business. However, anything that happens on those settlement lands is very much the state's business and the town's business, because they're no different than any other lands in the town or any other lands in the state. They're termed settlement lands for a reason. They were the product of a settlement, negotiated settlement between the federal government, the state of Rhode Island, and the Narragansett Indian Tribe. As part of that settlement, the parties agreed that the state laws and jurisdiction, both criminal and civil, will apply to any activities on those settlement lands. And in addition, the state jurisdiction, when they delegate zoning and planning and other avenues for legislation in town ordinance, town laws applied to those settlement lands. That's because of 25 U.S.C. 1708, which is a federal statute, and there was many years of litigation with the tribe saying, that doesn't apply to us, you can't apply your laws, state, and the state and town saying, yes, we can. And the First Circuit Court of Appeals ruled in favor of the state and the town. In a decision at 489 F. 3rd 16, Narragansett Indian Tribe versus state, they said the state may enforce its laws on the tribe's commercial transaction with outsiders. And in another case, 19 F. 3rd 685, it follows that the state may delegate a portion of that sovereignty to the town. The well is located in Indian Cedar Swamp. It is part of conservation lands. Both town and state laws apply to where the well, the dot, if you will, is presently located, and we look further to briefing that issue on behalf of the town as to what that means. Thank you.